It's a ritual, right? If you're a young lawyer, then you will at some point, either quite consistently or infrequently, have to brief an older lawyer or a senior counsel, as the case may be. So, well, how do you approach that?
Preparation, preparation, preparation.
Take the hearing and take the conference as if you're arguing the matter yourself. As long as you do it with the same intensity and the same focus, then everything that you need to cover will be covered.
Right? It's very important in the context of the process of your own learning. It's not just about telling your client's story. It's not just about briefing this senior who will in turn hopefully argue this, in a competent fashion. It's a little bit more. It's about you performing, you learning how to tell the story that is a case in the context of adversarial litigation, in the context of a finite amount of time, because time is premium, and in the context of often conferences being settings where other people are also trying to perform and dazzle.
Before every big hearing or even a small hearing, it is preferable that the briefing lawyer first makes a checklist of what all has to be, number one, taken to the senior for the briefing, number two, finally prepared for the court.
Prepare a brief list of dates, not like the lengthy list of dates which is drafted and which is part of your pleadings. A brief 2-page list of dates with reference to what the page numbers are.
And a brief list of propositions.
As to what you think are the arguments relevant in the matter.
The complete papers of the matter.
If you think any document is relevant to put forth that proposition, the reference to that document, and any case law, just the paragraph numbers. So if you prepare a brief note, it really helps even you, I think, at the time of conference, because you're more focused. You don't ramble, you're not all over the place.
Secondly, you must have sufficient copies not only for the senior, but also for the court in advance and not merely at the last minute.
If you're briefing a senior counsel, they're extremely busy and they have several cases.
Invariably, you will have a half an hour or 45 minutes to tell the story of your case from your client's perspective.
All of them will give you 15-20 minutes.
You will have to come to the point very quickly, just like the way you would come to the judges to the legal point which matters very quickly.
And importantly, you must understand that the senior may not be as attached to the file and the brief as you are. And he may simply want to know the big picture, apart from certain nuances which are critical to understanding the big picture.
So therefore, you must have a conception of your own case. And the only way you can do that is by knowing your brief really, really well, thoroughly.
So as opposed to constantly obsessing with minutiae which may not really help put forth your case in the best possible fashion, you will have to identify certain broad points and take him through the relevant documents.
What are the questions of law that are presented if you're at an apex court?
Specialist litigators have a tendency to assume that the senior knows the subject and the intricacies of the subject as much as they do. And they also assume that the court also knows this. And this is a mistake that they make. Either you take the senior through the basics of the particular subject before you introduce him to the facts of that particular case, or you tie certain special aspects of the subject to general principles of the law before you explain the facts of the case.
What are the important dates? What are the page numbers which seem to suggest, therefore, that the case is in your favor or otherwise? What is case law that is relevant?
Carry the case law with you, show the senior advocate what the case law is.
There's no point just telling them, this is something which is helpful. You need to mark it out for them, make it easier for them.
And of course, most importantly, you should also inform your senior advocate what the drawbacks in your case are.
Because this is an adversarial system, and therefore you should know both sides of this story.
Your advocate needs to know what is in your favor as well as what is against you, so that he has time to prepare for it.
So talk yourself through the brief. What are the 2 or 3 most important points? Is the next day a final hearing, in which case, this counsel that you're going to brief may have to argue a whole day or may have to argue an hour? Or is it a miscellaneous day? Is it a Monday or a Friday where the hearing of your case, whether notice will be issued, will be decided in 2 or 3 minutes? So strategize that, because if it's a non-final argument kind of hearing, then really it's about knowing those 2 or 3 most important points. And it's about knowing those 2 or 3 or a single case that covers your story. It's about actually enabling the counsel who you brief to encapsulate that brief story in 2 or 3 minutes. And that is a hard task.